On that, when he faced a subpoena, he didn't raise any legal arguments. He engaged in a course of deceitful conduct, according to the indictment. That was a clear crime if those allegations are true, and was outrageous.
Hey again, everyone. It is 5 o'clock in New York. I'm Alicia Menendez in for Nicole Wallace. We have new reporting today on a potentially damning piece of evidence in the classified documents case. Conversations between Donald Trump and his attorney, where it could not have been made any clearer to the ex-president that he was on the brink of committing a crime. Trump currently faces 40 felony counts in the federal classified documents case, 8 of which are tied to his efforts to stonewall the federal investigation that alleges he hoarded hundreds of classified documents at Mar-a-Lago, in a basement, in a bedroom, in a shower, and in an office. Some of those documents containing some of the most sensitive national security information imaginable. Now, ABC News reports that one of Trump's attorneys warned him he had no choice but to hand over those documents following a subpoena from the Justice Department, because not complying would be breaking the law. That attorney is Jennifer Little, who was hired back in March 2021 and currently represents Trump in the Georgia election interference case. ABC News reports that 12 days after the DOJ issued its subpoena in May of 2022, Little informed Trump that the stakes were now much higher. From that reporting, quote, she told Trump that if after a diligent search of Mar-a-Lago, they found more classified documents and returned all of them, he would not face legal jeopardy. But she told Trump if there are any more classified documents, failing to return all of them moving forward will be a problem, especially because the subpoena requires a signed certification swearing full compliance, the sources said. Once this is signed, if anything else is located, it's going to be a crime. Sources quoted Little as recalling she told Trump. The sources said that when investigators asked Little if those messages to Trump landed, she responded, absolutely. The former president said something to the effect of, okay, I get it. But apparently he did not get it, or just blatantly ignored the advice of his lawyer. Prosecutors allege that Trump, with the help of Mar-a-Lago staffers, subsequently hid boxes of documents to avoid returning them to the government. Little's advice to her client came during a meeting also attended by another Trump attorney, Evan Corcoran, who had just been hired to handle the case. Thanks to Jack Smith's indictment, we know Corcoran took copious notes following his conversation with the ex-president, where he described Trump as saying, wouldn't it be better if we just told them we don't have anything here? Trump has denied all wrongdoing in this case. And that is where we start this hour with the national investigative reporter for The Washington Post, Carol Leonnig, former Deputy Assistant and Attorney General and former U.S. Attorney Harry Litman, and New York Times reporter Katie Benner. It is good to see you all. Harry, I just think about how Jennifer Little's warning lines up with what Evan Corcoran said to Trump. You really begin, if you didn't already, to get a sense of Trump's mindset.
Well, you did already, and this really, it doesn't just line up, Alicia, it amplifies. So she says she told him that in no uncertain terms, that's the word, and that he clearly understood. You know, the receipt of a subpoena, as you could hear from Bill Barr's statements, is the ultimate focusing event in the criminal justice system. No more playing around. Had played around for 15 months. It really, even common criminals know that you at that point have to actually comply. And she made it 100% clear. And that basically, and the fruits of the search warrant set out much of the crimes that are alleged in Mar-a-Lago. That's what makes it so clean. He knew he had to. He didn't do it. He didn't. And he thereafter, there were more documents found there. It makes it a very straightforward case. This is killer testimony.
Well, Katie, it's just so striking to me. We know this pattern of Trump's, that he only listens to his lawyers when he likes what it is they are telling him. There have been many times when they have had to tell him things that he does not like. The difficulty of representing a client to whom you say, if you do this, it will be a crime. If you don't do this, it will be a crime. They say, I get it. And then they turn around and do the opposite, Katie.
And I was struck in particular by the warning that Jennifer Little gave about the seriousness of this, saying specifically that it required an attestation from a lawyer saying that all of the documents had been returned. This subpoena needed a lawyer's signature vowing that Donald Trump had actually told the truth, followed the subpoena, followed the law. And what I found interesting, too, is Evan Corcoran was in that meeting. He clearly took it seriously because he did not sign that attestation. He made sure he didn't. So I think you get a sense that his lawyers also have an understanding that they could be in jeopardy if they work for the former president. You know, Evan Corcoran doesn't sign the attestation, even though he's brought on specifically to handle this case, and he is taking the warning seemingly more seriously than Donald Trump.
Carol, there are two layers to the documents case, right? There is the hoarding, there is the taking the documents, having them in bathrooms and offices and places they never should have been. And then there is the obstruction, which is what this is really getting to. Explain how it all fits together.
That's right. I think one thing that's really interesting to focus on is how Jennifer Little makes clear to the president, look, we're somewhere different now than when the National Archives was asking you for these documents. You know, the National Archives and the FBI are pushing for Donald Trump to turn these over. The National Archives alone until basically February of 2022, pushing and pushing for months, asking him, we know these documents exist. We know they're missing. We're pretty darn sure you have them. There's all sorts of reasons to conclude that you do. Please, please, please give them back. At that point, it's basically a records chase. But they don't realize until that February of 2022 at the National Archives that actually many of the documents inside the 15 boxes that he does voluntarily return contain classified records. That's when they have a duty at the National Archives to refer this to the FBI and to the National Security Division of the Department of Justice. That's when things get a little stressful because the Department of Justice, their job is to ensure that there is no compromise of these records, that there is no spillage that then imperils national security. When there's information floating around in the country that might actually fall into the wrong hands, even foreign adversaries' hands, that reveals how we gain intelligence abroad, that reveals how the country is figuring out other countries' weapon systems. That's the National Security Division and the FBI's greatest worry then in February. What else is out there? We've got to figure it out. But things get even more serious when the department begins conducting interviews and the FBI with them and learns that, oh, there's quite a few more classified records likely on the property at Mar-a-Lago, and the subpoena is issued. There are 3 stages here, Alicia, where Donald Trump is on alert. We need you to comply. The most serious one is the subpoena, and that is where Jennifer Little says this could be a crime if we don't turn this over. The obstruction, the reason the rule of law works in the United States is because people realize they must comply. They must tell the truth when they're interviewed by an FBI agent, and they must provide truthfully all the records that are requested of them. But in this case, it's clear over and over again in the records before us and in the testimony that we've learned about from Donald Trump's own lawyers that he did not, and he intentionally, according to their own testimony, intentionally did not provide it.
Well, Katie, we have a real-world example of what it looks like when a former office holder takes classified documents. And this is where, of course, the Trump case, the Biden case, they diverge, which is Trump specifically says, no, these are mine, doesn't want to hand them over, has an attorney say, if you don't hand them over, it's a crime. He ignores her in comparison to the current president who says, come in, get what you need to get, take them back.
Absolutely. And what's so amazing about this is how patient, to be honest, how patient the Department of Justice and the FBI are with Donald Trump upon learning that he has classified classified materials in his possession that he's now returned. The patience that they demonstrate in the months before they actually subpoena the records, and then in the rest of the summer before they actually execute a search warrant, a surprise, what's normally referred to as a raid, although that's a touchy word, but execute a surprise search warrant at Mar-a-Lago. And I have heard from so many sources in the law enforcement community that were it anyone else that in February 2022, when they learn about these records, they would have been on the premises instantaneously. And that if this were any other person, they would have been charged and arrested likely after the raid returns boxes and boxes of additional classified records that have been concealed from the government.
Right, Harry, and this is why many of us feel like we're living in the upside down, because in reality, former President Trump was given a lot of deference, and he would like you to believe, quite to the contrary, that he was targeted and given none. I want to ask you, Evan Corcoran's notes, they were given to the special counsel's office because Judge Beryl Howell, we were just talking about her yesterday, made a ruling that the crime fraud exception applied. Explain that to me.
Sure. What it means is the communications. And this is the same thing, by the way, that happened to Jennifer Little. She resisted at first, and Beryl Howell said the same thing. When the communications are in furtherance of a crime, this being the crime that Carol's just laid out of obstruction, the attorney-client privilege goes away. And the judge found that it goes away here. It's one of several times that that's been found in all these Trump prosecutions. And only for that reason do we know what Jennifer Little told Trump so clearly. And I just want to emphasize, as Carol said, they give them all the rope in the world. But once you do a subpoena, they finally said, screw it. This has been taking too long. Here's your subpoena. That's the ultimate line in the sand. And that he then, basically decided not to comply. That's really the criminal moment par excellence right there. That's almost where you can start the case.